All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Thank you very much and welcome back. Now we will take submissions on the second limb of the matter, which is whether or not to adjourn the proceedings pending the return of Mr. Ruto to the courtroom. Mr. Khan, you may complete your submissions in this regard. You are beginning to address it.
Mr. President, Your Honours, I'm grateful. Your Honour, I've handed up a letter from the permanent mission of Kenya to the Secretary General of the United Nations on the 20th of September, which it was only then, this was not a public document at the time, in which the President confirmed that he would not be attending the General Assembly week in New York at the moment because of the Deputy's presence here. Your Honour, the letter written before the terrorist attack and sent to the Secretary General before this atrocity that's underway refers to the Constitution of Kenya, that the President, that either the President or the Deputy must remain in the country at all times. Your Honour, there's good reason for that, but it seems that the terrorists that have planned this attack aimed it at a period when they thought Kenya was most vulnerable, when there would be a vacuum of leadership, and that the President would be in New York and the Deputy would be here. Your Honour, it was a calculated attack to strike a country in its moment of weakness. Your Honour, the last page of the letter, I think, is relevant, and it states that, just one paragraph.
Mr. Khan, may I recommend that we limit our submissions to what the court can actually appraise as a factual matter, or, inevitably reasonable inference. I think we begin to enter the realms of the speculation when we start projecting what, one second, let me finish, in the minds of the terrorists who attacked.
Well, Your Honour, let me say this then. The prosecution, well, the application for an adjournment was compelled upon us because what we say, of course, is a eminently sensible and reasonable decision of the majority of the bench to excuse the Deputy President has been subject to appeal, and then suspensive effect has been granted. So the only available option, it seemed to us, was not to continue in the absence of Mr. Ruto, but it was to adjourn proceedings because of the pending appeals chamber matter. And that's why, Your Honours, we put forward the application to adjourn. Your Honour, this is not, and it really is, a point comes, Your Honours, where all of us have to act responsibly. This is not about who wins what contest. You know, Your Honours, on the last occasion, my learned friend repeated comments of an individual saying that Kenya may be becoming a pariah state. And then he stood up again and said, well, Mr. Khan says Kenya is not a pariah state, but I referred to Libya and perhaps it was Sudan. Well, Your Honours, apart from the fact that was in an entirely different context, saying that Kenya's cooperation is in very marked contrast, despite the protestations, to the Côte d'Ivoire, who refused to surrender Simon Bagbo, or in marked contrast to Libya, which refuses to comply with orders of the court. Kenya is, and it may stick in the throat of the prosecution sometimes, a model of exemplary conduct when it comes to the highest level cooperation with the International Criminal Court. And for the prosecution to say that somehow the defense should not use this tragedy when blood is still on the ground and people are shivering in fear as an opportunistic support for the bid to have the accused excused is really unwarranted, and it's objectionable and it is offensive. Your Honour, the prosecution may be feeling I hope, well, Your Honor, the last thing it is, put it that way, is opportunistic. It's driven by the needs of the Constitution of the Republic of Kenya, the needs of the victims, and it's not the defense being a lone voice. I think all right-minded people are saying that it is important. This court 173 Manveg life does not begin and start at its door. It is part of the international architecture, and Your Honor, in deciding or navigating the way forward for the court very rightly balances public interest, international public interest, in the same way that a domestic court will do so. So, Your Honours, we do deprecate the attempt of saying that somehow this is an opportunistic attempt. Your Honour, the other aspect is, and I think it shouldn't be lost on us, and it's really to support Your Honours, Mr. President's comments at the outset. Our condolences go not only to the people of Kenya, but there are British and there are French and there are Americans, and there's other Africans that have tragically lost their lives. A very renowned Ghanaian, Professor Kofi Awanur, who's 78 years of age, who was the well-known poet and author and also permanent representative of Ghana to the United Nations and chair of the Anti-Apartheid Committee, has also died in this tragic attack. So our heart goes out to all of them. Now, Your Honours, we do say, number one, we're grateful for the bench granting the adjournment. It's needed for the people of Kenya and the interests of justice in its widest form. But, Your Honour, when it comes to the length of the adjournment, because it seems, and we have no objection if Your Honour, it doesn't seem to us the trial, because of the prosecution's rigid position, that the trial can continue in the absence of William Ruto, but if it can, of course, so much the better. But, Your Honour, the period of 1 week is not sufficient. The prosecution, and of course none of us have had the responsibilities of the highest office of a country. Your Honours may have a better understanding than the prosecution, but for the prosecution to say that 1 week will be sufficient for a crime of this magnitude really shows how divorced they are from the reality of government and the responsibilities that is on leadership. Even the journalists, even if one had watched TV, CNN and BBC, the journalists are saying that they were having difficulty contacting officials because they're constantly in different high-level security meetings, National Security Council meetings, other briefings to deal with this issue. Your Honour, this is a complex matter. The immediate concern, of course, is the terrorist attack and those people that are still in the hands of these terrorists. But there is a wider issue, of course, about the Al-Shabaab attempts to attack the Republic of Kenya, because Kenya is on the front line on the war of terror. It is part of a group of African countries that are trying to stop terrorists on the front line. And, Your Honour, if these terrorists are not defeated here, they are a risk to the world everywhere. And so for the prosecution to glibly say either that it's an opportunistic attempt is derisory, or for them to say that 1 week is sufficient, bears no understanding to the essentials of government dealing with this issue, dealing with the aftermath. There are, of course, even in addition to security, there are issues which are important to government, which is reassurance, rehabilitation to those that have suffered, and there are funerals, tragically, that have to be attended. And, Your Honours, in all tragedies, presidents, heads of state provide that spine, that strength, that cohesion that brings a country together and stops it fragmenting under its pain. Your Honour, 1 week is not sufficient, unfortunately. Your Honour, the President, His Excellency Uhuru Kenyatta, made it clear yesterday.
Mr. Ken, I know you are, I do not mean to interrupt you on that train of thought. I just wanted to explain the reason why we pointed to the 1 week in the meantime, because that seems to be the least common denominator or factor in all of this. The prosecution had agreed to it as a limit, and for you, that included, of course, in what you wanted. You wanted more. So we wanted to deal quickly with the matter so that Mr. Ruto could proceed to the airport and limited it to the 1 week. In the meantime, subject to any further submissions you may make, you may continue. Just wanted to clarify.
I'm grateful, and we are cognizant, and we're grateful for the benches dealing with it in that manner. We do know that the common position was that the prosecution, despite how it was couched, was not to object to 1 week, and the bench, of course, I think very rightly and correctly, and we're grateful for it, his interest was to, in those circumstances, and after having considered the matter allow Mr. Ruto to get on a plane so he could go back home to his people. And Your Honour made it quite clear before the break that Your Honours were not close-minded regarding the length, and you were going to hear submissions on that, and we are grateful to it, the bench, for that understanding. Your Honour, His Excellency the President Uhuru Kenyatta said in a public press conference yesterday, and this is a sad reality that all leaders have in this day and age, unfortunately, and we've heard similar sentiments after the 7th of July bombings in the United Kingdom or after 9/11, that what the public don't see are how many terrorist attacks are foiled, are uncovered. And it is known that Al-Shabaab and this terrorist group is implacably opposed to democracy, the rule of law, and a pluralistic society where all people are free, regardless of their color or their religion or their creed, to live in peace, complying by the rule of law, not by fundamentalist, rigid, contorted, and twisted interpretations of a peaceful religion. Your Honour, these other attacks that are being planned and are underway are not matters to be taken lightly. We do hope, of course, that the appeals chamber will render its own decision on the merits of the prosecution's appeal at the first available opportunity. It's an important matter. It affects not only William Ruto, but 40 million Kenyans. But, Your Honour, in the meantime, what we do ask is that the court does balance the competing concerns, and in these circumstances, if the court feels that the case cannot proceed in the absence of Mr. Ruto because of the prosecution's position and the appeals chamber decision, then I'd ask that the case be adjourned for at least 2 weeks to allow matters of state to be dealt with, this current crisis and the terrorist attack to be quashed, and then the aftermath for proper planning and discussions to take place that may prevent reoccurrences of such terrible crimes in the future. Your Honour, that's why I say 2 weeks.
Question for you. You say that it was the suspensive effects decision of the appeals chamber that compelled you to move for adjournment in the circumstances. Did you or have you considered a request to the appeals chamber to consider or reconsider the suspensive effects decision for purposes of proceeding in the circumstances?
Your Honour, it's a very pertinent question. We have considered it. The reason I didn't pursue it are twofold. We wanted an immediate decision because of the proximity of time, and to be quite frank about it, it's normally the trial chamber tends to work more quickly for whatever reason than the appeals chamber of the court. That's just an observation, but I think it's borne out by probably statistical analysis. Your Honour, the second matter is that even if the appeals chamber were to have removed the suspensive effect, it wouldn't have dealt with the relief we're seeking, because the current individual would be classed as a victim witness, and even otherwise, Mr. Ruto's attendance would have been necessary by dint of the original decision of the majority of the trial chamber. And that's why, Your Honours, I thought it more prudent and effective to seize the bench of the application. Your Honour, so that explains my reasoning. Your Honour, the other matter that I do ask through the court is the prosecutor to reconsider whether or not she wishes to continue with this appeal, whether or not it is actually necessary in the interests of the wider mandates of her office and the responsibilities and the of the OTP and the mandate of the ICC. But, Your Honour, I can't do more than ask that the prosecutor reconsiders whether or not a very well-reasoned, we say, very balanced and flexible decision by the majority of the trial chamber should be appealed, or whether or not this incident helps show the prosecutor the good sense, the very good sense of the majority of the trial chamber in granting in rendering the decision that it did on the terms that it did, balancing all the various competing consideration. Your Honour, one hopes it opens the eyes to realities, but, Your Honour, I'm not the prosecutor, and I can do no more than simply request her, Madam Fatou Bensouda, to please reconsider her responsibilities and the merits of actually pursuing an appeal on this issue at all. If she doesn't pursue it, of course, it may be that it will help the people of Kenya and all individuals in a much wider way. But, Your Honour, that's a matter for her, not for me. Your Honour, so those are my submissions on the issue, unless I can assist further. I'm grateful.
Thank you very much. Mr. Steinberg.
Thank you, Your Honours. As my learned friend, I believe, has conceded, even in terms of the majority's original decision, Mr. Ruto would not be able to be excused from attending during the rest of this witness's evidence, since she is a dual status victim witness.
But that aspect of the majority's decision was necessarily an incident of exercise of what the majority then thought a discretion that it had, which means that it was still possible for the chamber to continue in the current circumstances had the original decision been allowed to stand. Isn't that the case?
Yes, I take your Honour's point on that. If the chamber did in fact have the discretion which the majority found it to have, then no doubt it would also have the discretion to revisit that decision, which was based on a balancing of the rights and of the interests of victims, witnesses, and of the accused. However, in the prosecution submission, the matter is unfortunately now out of the hands of the chamber, in that it is pending before the appeals chamber. And in my respectful submission, I need go no further than to read from the decision of the appeals chamber granting the prosecution's request for suspensive effect. It's decision 862. On Appeal 5, the appeals chamber notes the prosecutor's concern regarding the trial proceeding on the basis of an incorrect legal framework.
Mr. Steinberg, please hold the thought for a minute. Sorry, please proceed.
Thank you, Your Honour. The appeals chamber notes the prosecutor's concern regarding the trial proceeding on the basis of an incorrect legal framework and the difficulties that may arise should witnesses who testified in Mr. Ruto's absence be unwilling or unable to testify again. If the impugned decision were to be overturned and the trial had to restart in Mr. Ruto's presence. In all the circumstances of the case, the appeals chamber finds that the consequences of implementing the impugned decision prior to the issuance of the judgment of the prosecutor's appeal would be difficult to correct and may be irreversible, and that suspension of the impugned decision is warranted. Quite apart from the fact that this matter is pending the decision of the appeals chamber, in my submission, the appeals chamber has given a clear indication that the effects which the prosecution fears might arise if the trial proceeds in Mr. Ruto's absence are reasonable fears, and that in the circumstances it would be highly imprudent, at the least, to continue with leading of any evidence in the absence of Mr. Ruto. For those reasons, the prosecution has not objected to a limited adjournment in order to allow Mr. Ruto to make the necessary arrangements. Now, I hear my learned friend's arguments that 1 week will not be sufficient to resolve the issues arising out of this dreadful attack.
Before you proceed, I want to understand what you've said. Are you saying that the prosecution is of the view that this case needs to be adjourned now until Mr. Ruto comes back?
That is indeed the prosecution's position. Continuing then with the necessary length of the adjournment, the prosecution does not for a moment suggest that the aftermath of this attack will be dealt with in a week. And that is clear from the prosecution's written submissions, and any characterization of those submissions otherwise is incorrect. What the prosecution suggests is the following. Mr. Ruto knows and has known for a considerable time now that a trial is pending before this court. In the prosecution submission, a responsible position would have been to put in place the necessary mechanisms for the country to function without him.
What would those be?
Well, delegation of his functions to another responsible individual is the first thing which comes to mind. Now, Kenya's constitution is by no means unique when it requires that either the head of state or deputy head of state be present at all times. The constitution of my own country is the same, and I'm sure many other countries. But from time to time it happens that neither the head nor the deputy head of state is available or in the country for reasons outside of their control. In my country, this is dealt with by swearing somebody in as acting head of state. Now, I don't know whether my learned friend is suggesting that Mr. Ruto is the only person available in Kenya who is capable of dealing with this crisis. If that is the suggestion, I would suggest that it is not correct. Kenya faced security concerns before Mr. Ruto's election, and no doubt it will face concerns similar to that long after he's departed the scene. My submission is, and the prosecution's position is, that in the coming week, Mr. Ruto should take the necessary steps to put in place capable and responsible people to delegate the necessary powers to them in order to respond to the crisis.
Does the Constitution permit that?
My learned friend will no doubt be able to address on that. I'm unaware of that. But
It's your submission. You should be able to speak to it.
I have to come back to the court on that. I can't make a statement on that. I'm not aware of the answer. All I can say is I would be dreadfully surprised if it wasn't permitted, and that would, it seems to be a glaring omission, because it is always foreseeable that for some or other reason the deputy or the deputy president might not be available.
Judge Fremer has a question for you.
Mr. Steinberg, one question. You referred to the balance between the rights of accused and the interests of victims. Do you think that in this concrete case of witness P536, which also has a double status as a victim, is in her interest to adjourn the trial?
Your Honor, I would certainly not go so far as to say it's in her interest to adjourn the trial. But in balancing the interests of Mr. Ruto and of the victim and the witness, P536. The prosecution's position is that a limited and discrete adjournment for the period of no longer than 1 week would not unduly affect the witness. And I say this bearing in mind that I'm conscious of VW's assessment that the witness may be affected, but I've not yet heard any specific reports on the witness's views on this. I would not be surprised if the witness, learning of this terrible attack, would not take the position that of course, this must take precedence in some degree over my continued testimony.
I think that's a matter on which we will hear from the VWU somehow, whether or not the victim's view, what the victim's views are on it. Returning to the question of constitutionality, you said that if you'd be surprised if there was no provision made in the Constitution, in which case that would be a glaring omission. What if it is a glaring omission? Is it for us to correct it?
Your Honours, of course, this chamber has no powers to correct omissions in the constitution of a sovereign state such as Kenya. So no, that would not be the court's duty to correct. However, one should not lose sight of the fact in the prosecution submission that the chamber has already taken steps to ensure that the sitting schedule of the trial of Mr. Ruto and the second trial involving Mr. Kenyatta have not overlapped, so that one of the two of them may always be in the country to fulfill his presidential functions. Now, that being the case, I have yet to hear anything from my learned friend which indicates why Mr. Ruto's presence is essential. I'm not saying that he won't be in a position to contribute in one way or another, but my submission is that Kenya, as my learned friend has pointed out on numerous occasions, is a mature and functioning democracy with a democratic government, with law enforcement apparatus, with a functioning army, with a whole cabinet of ministers, including ministers dealing with internal affairs and security, with an intelligence service, and all manners of government who are available to deal with this sort of crisis. And in the prosecution's respectful submission, Mr. Ruto's personal presence in the country on an ongoing basis is not justified by this matter alone, and that the responsible position would be to ensure that the governance of the country is left in good hands in his absence. And I'm not necessarily referring to constitutional duties, but simply to appoint a crisis group of responsible ministers and officials to deal with this. Mr. Ruto will not be on Mars. He'll be here in The Hague with access to modern communication. He'll be available to get daily updates outside of court hours and to give instructions as necessary. Now, this may place an additional burden on him. I don't dispute that. We know that court days are long, and at the end of court days, one is tired. But like members of the prosecution and the defense, after court, we still carry on and do a full day's work. In my submission, that is not an unreasonable position. Now, to respond to one other criticism of my learned friend, the prosecution's comment regarding the fact that we hope this would not be used as an opportunistic attempt to advance a separate agenda. That was not the agenda of an adjournment of this matter for the purpose of attending to this crisis. That was prompted by the following statement by my learned friend at paragraph 4 of his request that was submitted yesterday, where he says the following: "The attack which started yesterday and continues to unfold is, regrettably in today's world, an example of situations which form part of the normal state affairs which fall within the portfolio of a country's deputy head of state." The prosecution's submission is that there is nothing normal about this attack. In our submission, this is exceptional, it is gravely serious, it has caused a number of innocent victims, dead, many, many more wounded, and many, many more affected in one way or another, and cannot be regarded as an example of the day-to-day business for which Mr. Ruto's presence is required in Kenya. So that if it is suggested that this should give reason for the appeals chamber to come to a decision which it might not otherwise have arrived at, that is most unfortunate, because this is not an example of the sort of thing, a genuine example of the sort of thing which the Deputy President would be expected on a daily basis to deal with. So the prosecution's point is, in a nutshell, this is an exceptional and significant event which justifies a short adjournment of the case in order to allow Mr. Ruto to attend to his duties and to make the necessary arrangements to deal with the aftermath in his absence. But that it does not go so far as to give grounds to the appeals chamber or to the prosecution to reconsider the matter presently on appeal before the chamber, the appeals chamber. Unless there are any further issues, Your Honour. I'm still on my feet.
Mr. Khan.
Your Honours, in our respectful submission, it's the prosecution that is using this tragedy as an agenda, fearful that its rigid and exposed position, seeking to set aside an eminently sensible, pragmatic and principled decision of the trial chamber, has been so terribly exposed for the straitjacket that it is, a straitjacket that we say is so fundamentally inimical to the proper administration of justice. Your Honour, my learned friend states in the one breath that, taking issue with my filing, and I don't cavil at a word of that filing, in this day and age, the tragic reality is which country has not faced terrorism and security threats? They are part of the day-to-day issues of government. They shouldn't be, but they are. Now, that may create an inconvenience to the prosecution's objective here, but it's a reality that I think any sane and objective person, not emotionally tethered or linked to a particular result, would be forced to accept. Your Honour, my learned friend states that there's nothing normal about a terrorist attack. Well, there isn't. But it's part of the day-to-day affairs dealing with the threats of terror. But the issue of normalcy goes out of the window because, to the greatest of respect, however eminent the lawyers are in this room, there's nothing normal about being a president or being a deputy president. Nothing normal at all. And when my learned friend makes submissions, Your Honour, it behaves all of us to make submissions that are not simply knee-jerk reactions, convenient smokescreens to pursue a particular end. As officers of the court, we must do our best, we fail on occasion, to put forward arguments based upon law, reason and logic and truth, so that the bench may come to the right decision. Now, Your Honour, my learned friend's proclivity of knee-jerk reaction submissions is unfortunately exposed by his throwing out of the Constitution of Kenya. Well, Your Honours, I've got a number of observations. Firstly, the license that the Deputy President swears somebody else in is tantamount to a legal coup, regime change, through the device of the Office of the Prosecution sitting opposite. Your Honour, it is not said that the only person, Kenya is a rich country, in personnel, in human resources, and people of fantastic potential and ability. If anybody has spent time in Kenya, and not as a tourist, but actually living there, they would realize the wealth of that country and that continent. But, Your Honor, the only person, I'm not saying William Ruto is the only person that can solve the problems of the world. I'm not saying he's the only person, even with the president, that can solve the problems of Kenya. But they are the only people democratically elected to do so. And that is a fundamental reality. The rule of law goes very neatly together with democracy. And the democratic essential reality that the deputy president has a massive democratic mandate to perform should not be glossed over so lightly by the prosecution's fallacious understanding of the Constitution of Kenya to say that there should be regime change and somebody else can be sworn in. Your Honor, an individual is presumed innocent. The people of Kenya have voted for William Ruto. They have a right to the government they deserve. And Your Honours have acknowledged that by allowing Mr. Ruto to leave the seat of the court to deal with the tragedy that is unfolding in Kenya today. Your Honour, cavalier submissions should be given short shrift by the prosecution. I'm told by my learned friend, Mr. Kato Keegan, who's appeared several times before the Supreme Court of Kenya and is a senior advocate, that there is no constitutional provision of that sort. And I deprecate in reality even that a prosecutor in good conscience could even suggest such a thing. It's irresponsible prosecutorial utterances without any understanding, we say, of the consequences in the Republic of Kenya. But, Your Honour, be that as it may...
Mr. Khan, you may make your submissions, but let's remove the aspersions from them.
Your Honour, but we do say, I take that on board, but Your Honour, we do say that they're irresponsible at a time when there is a terrorist attack underway. It's a license that a vacuum. Somebody else should be sworn in. Your Honour, the democratic essential reality that William Ruto is the deputy president. Many countries, many individuals may not have wanted him to have been elected by the people of Kenya, but he was. And Your Honour, that reality should be respected, we say, has effect and is germane to the application before the court. Your Honour, issues of terrorism. You know, I remember years ago reading George Shultz's book, even in the 80s, with Ronald Reagan, and he said they had this tent, communications tent, that he used to go into when they were discussing issues of the Cold War. Well, Your Honour, not all countries have the technological ability of the United States of America regarding secure communications that are dedicated to the President. Not everybody has an Air Force One. So, Your Honour, security issues dealing with a violent terrorist group that has the audacity even to Twitter and have social media accounts cannot, with respect, be done via a mobile phone or on the telephone. Executive decisions need to be made. The court should be flexible enough to realize it. It has been at the present. Your Honour, our simple submission is that 1 week is insufficient. It requires 2 weeks if the bench is of the view that the trial cannot proceed in the absence of Mr. Ruto. Your Honours, the urgency of the application was to allow the court to consider the merits of the request so that Mr. Ruto could go. Now it's been done, Your Honour, I do inform the bench I will be filing today an application to the appeals chamber to lift the suspensive effect in any event. Your Honour, I think that is a matter that the appeals chamber should be appraised of. They will decide it on the merits of the application. Your Honour, I'm grateful, and those are my submissions in response.
For the record, the information received by the chamber on this thing from the VWU is that they do recommend not adjourning this witness's testimony. Both out of VWU's own appraisal of the sensitivities of this witness, as well as VWU's report of the result of their own consultation with the witness, that the witness wishes to proceed with the testimony. That's just to put the matter on the record. Mr. Nderitu, are you in a position to submit on this matter?
Yes, Mr. President, Your Honors. I think I will want to just leave it to the trial chamber to reach a decision on this. I believe that either way, by the time I would be required to examine the witness, if leave is granted, I will be in a position to do so. But speaking on my own behalf, of course, I would be happier, I must say, if it was possible to have an adjournment.
Mr. Katwa Keegan.
Mr. President and Your Honors, we, on our part, as Mr. Sang's defense, would request that the matter be deferred until Mr. Ruto is able to resume the attendance of the hearing. Speaking on my own behalf and on behalf of my team, they would also like an opportunity to mourn the loss that has occurred in Kenya, both in the immediate sense of loss of their friends and in the general terms that Kenyans have lost life and property. I am instructed also to highlight the seeming discomfort that would arise if the proceedings were to go on in complete disregard of the tragedy that has befallen Kenya. And the request for adjournment is on that additional ground that there is some awkwardness in Mr. Sang seeming to want to go on with his hearing, notwithstanding the tragedy that has befallen the Kenyans. On our part, we have no objection to the days that have been deferred being compensated, either by coming in earlier or coming in later, depending on the court's directions. We are agreeable to have the dates compensated. We had in our filing suggested an alternative to proceeding in the absence of Mr. Ruto. That filing was, however, made before we had received the filing from the prosecution, where the prosecution and happily the victims also concede that the tragedy is significant and warrants the adjournment. And in the circumstances, we do not maintain the insistence, or we do not maintain the submission that we proceed in the absence if the court is not minded to grant the proceedings in his absence. We are also alive to the fact that that witness is a dual status witness, both a victim and a witness, and proceeding in the absence of Mr. Ruto would need an adjustment or a revisit of the orders of the court that Mr. Ruto be present when a person who is also a victim is testifying. In response to the issue that is peculiar to Kenya, may I observe that Article 149 and Article 150 of the Kenyan Constitution does not allow for delegations of the powers of the Deputy President unless the Deputy President is either completely unavailable or is incapacitated or has been impeached. And neither of all those circumstances obtain in this situation. The last observation I wish to make is that the defense of Mr. Sang are grateful that for the first time the Office of the Prosecutor acknowledges that Kenya is a functional state, in acknowledging that it has a presidency, it has an executive, it has cabinet, it has an army, it has an intelligence organization. That is a concession that so far the prosecution's case has never acknowledged. Apart from those ones, Mr. President and the honors, we do not wish to say anything more. Thank you.
Thank you very much. The chamber will adjourn now, and as if we're in the morning break, we will reconvene at 11:30 for a ruling on this matter.
All rise.